All right. All persons having lived before the honorable judges now presiding on the District of Columbia Court of Appeal. Draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please be seated and come to order.
Good morning, everyone, and welcome to the District of Columbia Court of Appeals. We have 3 cases on this morning's regular calendar, and we will get started with the first one, 22 FS 213 and 22 FS 214, in re petition of J.G. and R.M.
Good morning. May it please the court. My name is Murphy Henry. I represent the appellant TL, and I would like to reserve 5 minutes for rebuttal. TL, the biological mother of KL and KT, seeks reversal of the judgment affirming the magistrate judge's issuance of final decrees of adoption and the order waiving her consent to the adoption. TL is requesting a reversal because 1, the petitioners failed to meet their burden by clear and convincing evidence to overcome the presumption of parental fitness. 2, the trial court erred in finding that the petitioners met their burden of proof that TL was withholding her consent to the adoptions contrary to the children's best interest. 3, the court erred in improperly comparing TL with JG and RM. And finally, that the court erred in disallowing testimony regarding the availability of TL's family as a support to her. With respect to the first argument, TL, the court found that TL was unfit mainly on 3 areas. First of all, substance use. The court found that TL failed to address her substance abuse that caused the children to come into care, and concluded that TL continued to use PCP and alcohol throughout the pendency of the case. However, the testimony and the evidence that was presented to the court did not support that conclusion, those conclusions. TL admitted that she used substances in the past, and there was only 1 positive test. And when she admitted that she used substances in the past, the testimony that elicited that when that testimony was elicited, she was talking about before the time that predated the entrance of the children into foster care.
Right. So there's drug use before the initial neglect finding.
Yes.
And then the evidence of during the pendency and post neglect finding is what there's at least 1 positive, I believe, PCP test and
Yes.
5 missed tests with excuses ranging from I hurt my foot on the way there, the bus wasn't running. I don't remember what the rest of them are. Do you want to detail what that testimony was about all the missed tests?
So the missed test, there was 1 positive test for PCP in 2020, October of 2020. The missed test, there were about 4 of them. I think the court cited 2. 1 was that she had hurt her leg when she was trying to get on a bus, and so she could not ambulate, and the social worker testified to that also. Another one, the buses were not running, so she could not get to the testing site. And there was.
I mean, this is some testimony, good, but if I remember correctly, the judge didn't credit that. The judge said, I'm going to draw an adverse inference that all these missed tests are because that in fact she was continuing to use drugs. Am I misstating what the judge's findings were? Or do you think the judge was just outside of its discretion as fact finder to make that credibility finding?
But I guess our argument will be that even if the judge made that inference, it doesn't necessarily speak to her continued use. That was only 4 tests over a period of time. So
weren't there many more missed tests?
there were the record doesn't show all the weeks of testing, and mainly I think because there was a period where testing could not be done because of the COVID virus, and there was no testing facility available.
When was the last negative test?
The last negative test was sometime in July of 2021.
Let me ask you too, I think it's unfair to hold this kind of thing against someone, but what do we make of the shortly before the adoption trial or the trial determining the best interest in all, Ms. TL going into detox, essentially, like going into treatment?
She testified that the reason why she did that was because she felt it would make her look good, that she was making efforts to address the issues that the court had highlighted that needed to be addressed. So that was her explanation of why she did it.
And so you would say that also the same explanation applies to the observed change in behavior in the record, where after that and shortly before the trial, there was just exemplary behavior, friendliness towards everyone and the children, and the concerns that were being testified to just weren't present there in that moment.
I'm sorry, I don't quite understand the question.
Well, would you say it was the same? It appeared to me when I read the record that it looked like this going into treatment was being further kind of upheld as something that was addressing substance issues, because all of a sudden after that and leading up to the hearings, the trial, Ms. TL's behavior changed and was completely positive according to the record. I was asking if perhaps the same explanation that it would make her look good was the same explanation for the behavior changing. Would you say that as opposed to some sort of substance abuse being cleared up?
TL would maintain that there was no substance use present, and she went into detox just because she wanted to show that she was making some efforts to do what the court had instructed. If her behavior changed, well, if her behavior was exemplary afterwards, I guess she would not attribute that to necessarily going into detox, but that's who she was. Yeah.
And then do you want to talk about the continuing assaultive conduct finding, which seems to be the other big piece of the trial court's analysis?
Yes, there was an arrest right before the adoption trial started. And the rest was an allegation of assault. However, at the time of trial, that had not yet been dealt with at the Superior Court. Besides that, there was no other.
Wait, I take it what you're telling me is it was not adjudicated. There had not been a plea, there had not been a trial,
No.
or anything like that.
Correct.
Are you telling me that if there is misconduct that is not adjudicated in court, the trial court could not consider that?
I'm not.
Was it denied by your client? Did your client say, no, I didn't do any of that? I did not grab a knife. I did not stand on the roof of the house prior to being arrested to evade the police.
That was not a topic that we examined at the trial. because there was a pending criminal case. And so in order to preserve TL's Fifth Amendment rights, we did not deal with that issue in particularity. However, what our argument is that before that time in July, when she was arrested for an assault, from June of 2020, after she got released from prison, until that time, there was no other instance of any arrest or.
I mean, it's not a very big window you're talking about, you know, you're telling me a window that's less than a year, whereas my understanding, you're talking about from June 2020 to the trial, which I believe was in June 2021, right?
The trials began in August of 2021.
In August 21. Okay, so I'm sorry, slightly more than a year. Meanwhile, during the pendency of neglect proceedings, after the children had been removed, she had how many arrests? 4 or 3 or 4?
No,
Two that resulted in incarceration, I believe, right?
the arrests that she suffered were related to the reasons why the children came into care.
I'm just asking for a number. If you,
Okay, so from my recollection, she probably had 2 arrests. I'm not entirely clear on that.
so she had 2 different stints of incarceration, correct?
Yes,
Were those both related to the same offense?
yes,
And one was after she was released, presumably for some violation of supervised release, right?
that's conceivable, yes.
What was do you know what the violation was?
I'm not clear on that.
Okay. So at least one arrest, one violation that led to reincarceration, and then a 3rd arrest, really just a month before the trial started. What, with that factual record, how could we say that the trial court's finding that there was clear and convincing evidence that she continued to engage in, you know, conduct that would be detrimental to the kids? How could we say that that was a clear abuse of discretion or clearly erroneous in some way?
I think our quarrel is about the word continuous, because she didn't, like, there was that period from December 2019 to June 2020 when she was incarcerated on two different occasions, but it pretty much covered those 6 to 7 months. And then she was not incarcerated nor arrested until right before the trial. So the continued is what I think our quarrel is with, that there wasn't a continual behavior, criminal behavior on her part during the pendency of the case.
You mean just because, well, could the court simply have meant there's more than one instance in the relevant period of time? When you want that to mean there's a lack of consideration of a time period of no problem. But why isn't that just, unless you're saying what was considered was improperly considered, isn't this just a semantic dispute?
Well, I think it doesn't give any credit to TL for the period when there was nothing going on. And it just kind of makes it.
Understand about that period where there was nothing going on. And maybe I'm missing in the record where this specifically was, but during that period where nothing was going on, isn't that when the incident occurred that led to the library ban?
Yes, I think that happened during that period. Yes. So TL the second point that of contention for TL is that the court found that she withheld her consent to the children's adoption contrary to their best interest. our arguments mainly focus on, I'm sorry, I just need some water. The court held that she didn't make herself available during periods of incarceration, but our argument about that is that, the incarceration occurred right at the beginning of the neglect case. And so then she was available afterwards. She was available from June 2020 until the adoption trial began in August of 2021. We also argue that she did have relatives that were willing to and available to support her in taking care of the children. So the law does not require her to be perfect. And so she had support in the community by her family, her sister, her daughter. There was even her mother that they were all available to help her. She, with respect to her physical, mental, and emotional health, we agree with the findings of the associate judge that the mental health, that there was not sufficient evidence on this record to uphold a finding that she was unfit based on her mental health. And so with that argument, we would say that the court abuses discretion in determining that that she did not have the physical, mental, or emotional capacity to take care of the children. We also had evidence of the fact that she did at that time, her daughter who testified was an adult, and she had raised her. And so even if you consider, I think there was some discussion about the fact that she had this history that predated the neglect case, but even if you consider that, she had a daughter that she raised successfully.
So I think counsel, one difficulty with this case is you're sort of litigating the facts before us. And when we're not a fact-finding body, there's a magistrate judge in a trial court that weighs all this and comes to its conclusion. So as you detail the facts, I mean, are you telling me that the trial court considered factors that it shouldn't have, that it failed to consider factors that it should have? Or are you just saying, in total, these 5 factors, when you look at the statutory factors, there is no way for a trial court to come to the conclusion that she was withholding her consent to adoption in the best interest of the child? Which flavor of argument are you making now?
So we're arguing that when you look at the factors, that the court should not have come to that conclusion that she was withholding her consent to the children's adoption contrary to their best interest.
And Ms. Henry, we will give you some more time in rebuttal, but we'll hear from is it Ms. Risciuto?
Thank you.
Risciuto first. Thank you. And Ms. Risciuto, how will you be dividing time with the government? And
Yes,
okay.
yes, Your Honor. I would like to divide my time evenly with the district.
Okay.
Good morning, and may it please the court. I represent petitioners J.G. and R.M. I, at this point, would like to touch on the issues that were just discussed by the appellant. With respect to the substance use piece, it's our position that there is more than ample evidence in the record to support the trial court's finding that Ms. TL had a pervasive and continued problem with substance abuse. We have her own admissions in the record. We have several positive tests in the record. I believe one was October of 2020. There's also lay opinion testimony in the record by my client J.G., where a visit, I want to say either in December of 2021 or January of 2022, Ms. TL appeared to be under the influence during that video visit. And this court has accepted lay opinion testimony in the past with respect to.
Yes, but wouldn't your client have an interest in that lay opinion testimony?
She could, but she was also supervising the visits to a certain extent. And both JG and RM throughout the life of the case had attempted to provide more contact than less contact with both the family and Miss TL to provide additional. And so while there is always an inherent interest when you're an opposing party, she was under oath. She was speaking her perspective. And then you also have, in addition to that, you have Miss TL's erratic behavior throughout the life of the case. I would point to court's indulgence.
If we were to rely on the erratic behavior, how would we know that it was anything in particular? Like, how we know the particular cause of it? Does it seem like a fair assumption to say it was drugs versus mental health or even stress in a given moment or a situation?
It could be any of those things, but when we're looking at the best interests of the child standard, which is essentially what the court's main consideration is, you want a parent who is not going to consistently act erratically. For example, the incident right before the trial where she was up on her roof waving around a kitchen knife. I would state that that actually is in the record. I personally questioned Ms. TL regarding this. I asked her a question regarding it being a butcher knife. She corrected me that it was a kitchen knife. So she fully admitted that she was up on the roof with the kitchen knife. We also, without objection, submitted portions of the body cam footage of the incident where she was struggling with the police officers at the time. And so there is also visual evidence in the record regarding that incident that occurred right before the adoption trial took place.
Ms. Henry is talking about the basically the court's failure to give TL credit for those periods of relative calm and stability. Isn't that the case?
I don't think that the court can credit just certain periods of time. Children need consistent stability from a parent, particularly children the ages, I believe at the time of trial were 9 and 4. So having pockets, even several months of stability is not something that would lend towards their best interests. Additionally, TL, I know that there's been contention, particularly with the substance abuse issue, that TL entered detox to make herself look better. However, if TL did not have a drug problem, why would you enter detox? Why would you have that conversation with the ongoing social worker? Why would you ask for her help to enter PIW? Again, this just goes to—
Why would entering detox not be a positive thing where Miss TL is trying to maintain and get herself back to stability for her children?
It is a positive step, but the children had been in foster care since 2019. We're talking about now TL just starting to address her problem in 2021. The children have been now in foster care for almost 2 years and had achieved stability with JG and RM. And so the focus is also on what's best for them. And having them linger in foster care for years to come potentially while Miss TL deals with her substance abuse problem is not in their best interest.
You keep skipping to the best interest of the child analysis, where I think, a lot of this argument is about fitness, which of course has to come first. It's not, you don't just go, it's not who are the children going to be better with, which is where you're starting. The first question is this parent unfit, which means, if I get this, I think it's whether or not, let me just read the statutory standard. The parent's intention and ability over time to provide for a child's well-being and meet the child's needs, with the basic inquiry being whether the parent is, or within a reasonable time will be, able to care for the child in a way that does not endanger the child's welfare. So you keep saying, the hallmark of this is the best interest of the child and they need continuity. But the real question, I think, is whether or not the degree to which there's a lack of continuity here endangered the children's welfare. So going back to Judge Beckwith's question, is it fair, is it right that the trial court didn't take, this year of stability into account and occasional bumps in the road, if you want to call it that, lapses that happen every year or so, and there's family members who will cover those lapses, whether or not that endangers the child's welfare?
We would argue that there wasn't in fact a year of stability, that within that year period, I think that the record is clear that Miss TL had multiple incidents. There's the incident with being banned from the library.
Why was that again? I just don't remember.
Why was Miss?
Yeah, what was the record on why she got banned from the library?
She became verbally assaultive to a different child who was in the library, not her own children, but she became verbally assaultive towards a different child in the library, and she was ultimately ejected. That's my recollection of the incident. Also, with respect to the criminal matter that was addressed, the plea deal that she entered, it was a global plea deal. And that was exhibit 19 that was entered, the sentence and plea agreement, Your Honors. And it was in part, she pled guilty to assaulting her eldest daughter, NL, which is the respondent's older sister, and attempting to sex traffic her. So when we're talking about what she pled guilty to assaulting her older daughter and attempting to sex traffic her. That was what her actual plea was. That wasn't it was not after trial. She pled to that.
You said it was, or it was not after trial?
It was not after trial. She
was that I don't recall that being any part of the trial court's findings. So that you think that was in the record?
It is in the record. It is exhibit. It's a judicial notice exhibit. It is exhibit 19. It's 2019 DVM 21263. And that was entered without objection into the record. And we would also note, for the reasons that I've mentioned before, that the record is replete with TL's assaultive and combative conduct. In addition to the incident where she was on the roof of her home right before trial, there's also testimony in the record regarding her interactions with the ongoing social worker, Ms. Moore. And that occurred within 2 months of the trial, from the start date of the trial. And so we would submit that there is more than ample evidence in the record for there to be a finding that Ms. TL is unfit. The other thing I would note that was not mentioned, because we focused on the substance abuse and the assaultive behavior, but throughout the life of the case, Ms. TL did have the opportunity actually to participate in medical, educational, and therapeutic services for the children. And the record demonstrates that she did not do any of those things. In fact, when she was questioned on direct examination, she could not even name the children's teachers. And there was no barrier to her to have that type of contact. Her rights were intact. She had her educational decision-making rights. And so she had more than the ability to have conversations with the teachers. And I would also note that her visitation had never moved beyond supervised visitation due to her behaviors in part and her unaddressed issues. And so it's not as if she had made progress in certain areas. There was a general lack of progress in every area with respect to Ms. TL. Okay. And then we would also submit that because the court did make and properly made the finding that Ms. TL was unfit, that the court also properly held that she was withholding her consent for the respondents. Oh, I was withholding her consent for the respondents against their best interests. And I realize that I have.
It goes fast. So
It goes really fast, so I apologize.
thank you. No problem, Ms. Rashudo. We will hear from Ms. Anderson now.
Thank you.
Morning, Your Honors. Stacey Anderson, may it please the court, on behalf of the District of Columbia. Your Honors, we are asking that the court affirm the adoption decrees in this case. Based on the discussion this morning, I think the court has a firm grasp of the facts in this case. It is our position that the mother's ongoing substance abuse and assaultive conduct established her unfitness, and the trial court committed no error in citing those factors and in concluding that she was unfit for those reasons. In addition, I think the court properly weighed the best interest considerations under the TPR factors and concluded correctly again that the best interests of the children were to be adopted by J.G. and RM. I'm happy to answer any questions the court might have about the arguments in the district's brief or otherwise.
Well, I'd like to clarify one point with regard to the magistrate judges. Negative inference on the testing.
Yes.
Did that include time periods where Ms. TL was incarcerated?
Your Honor, it's not entirely clear from the record. The court was not specific about that. We know that TL was ordered to drug test beginning in December of 2019 at the initial hearing. She was incarcerated for a period between December and March. When she tested for the first time in March of 2020, she tested positive. She was then incarcerated for a 3-month period. She was released from incarceration in June, and that's when she underwent her APRA assessment. But she didn't drug test again until October 2020. So at least between June and October 2020, it appears that she would have been able to attest and failed to do so. In October 2020, she again tested positive for PCP. And then after that period in time, the drug tests became sporadic. Once in December, once in January. She missed several tests in May. She did test negative in June of 2021. But I think, again, considering the fact that she was ordered to drug test weekly, the court did, I think, credit some of her explanations for failing to test, but with that many tests missed, I think the court correctly drew the inference that she was not testing because she would have tested positive. And again, as we get closer to the adoption trial, her behavior with respect to the butcher knife incident, with respect to the fight she got in while she was intoxicated, and then finally her detox, all would show that in fact that inference was supported based on that evidence. If there are no further questions, we'd ask that the court affirm. Thank you.
Thank you, Ms. Anderson. Ms. Henry, we will give you 3 minutes for rebuttal.
Your Honor, I really don't have a rebuttal. I'll just ask the court to reverse the finding and hold it that she withheld her consent contrary to the children's best interest, and that and reverse the adoption, the granting of the adoption. Thank you.
Okay, thank you very much. Thank you to all parties for your briefing and your arguments today. And the case will be submitted. The next case on this morning's calendar is Derrick R. Moore versus United States, number 21 CO 106.
If it pleases the court, I'm Fleming Terrell on behalf of Amicus, the Public Defender Service. I've spoken with Ms. Beskier, counsel for Mr. Moore, and we thought it would make for a more efficient and clear argument if I first address the legislative history and statutory interpretation issues discussed in our brief before Ms. Beskier speaks. Okay. In that case, if it pleases the court, I'd like to reserve 2 minutes of my time for rebuttal. There's no dispute that IRA's text, structure, and the legislative history detailed in our briefs all demonstrate that the statute's purpose, as it says right in its title, is to reduce incarceration among a cohort of people whose culpability is diminished and who are more likely to be rehabilitated by virtue of the fact that their offenses were committed at an age when science tells us that young people are physiologically and psychologically less able to control their impulses, more susceptible to outside influences, and less able to grasp the long-term consequences of their actions. It's a remedial statute, and its predominant focus is on rehabilitation. In order to ensure that courts interpret and apply IRA consistent with that remedial purpose, the council mandated through factor C10 that they must bear in mind in every case the statute's science-based animating principle, that young people, even those who commit the most serious crimes, are categorically different from adults in those two key ways I mentioned. They are less culpable and more apt to be rehabilitated, and that those counsel against lengthy sentences. So C10 doesn't just add weight to the relief side of the balance in every case, which it does. It also provides a lens through which courts must view the other enumerated factors and the interests of justice that the statute seeks to advance. We know that from the text of the statute that C10 is written in categorical terms. It doesn't ask whether the nature of a particular crime seemed youthful. It doesn't ask the court to investigate an individual defendant's specific attributes. We also know it from the legislative history that C10 captures the insights that are elaborated in more detail in the social science and science research on which the council relied and which the Supreme Court endorsed in its line of juvenile life without parole and death penalty cases. And those insights are that young people's incomplete neurological and psychosocial development predisposes them to impulsivity, risk-taking, susceptibility to peer and other influences, and an inability to consider the consequences of their actions. So it's not just that they don't exercise the judgment an adult would, but that they can't yet.
So what's wrong with the trial court saying? This part of what I think the trial court was saying here was, well, some of those factors really don't help. Impulsivity, this doesn't appear to be an impulsive crime at all. This seems to have been somebody lying in wait. In terms of influence of peers, it really looks like he was the ringleader of this attack. And so that really doesn't counsel against him either. I take your broader points that C10 is meant to be something on the side of the scale of Mr. Moore, but I don't see why when you say, well, youth are generally less culpable, a judge can say, well, here, many of the reasons why, or in any other case, many of the reasons why youth are less culpable don't apply to this particular crime and take into account the nature of the offense in that respect. I understand some of the other factors you listed, like ability to like appreciate the consequences of their actions might factor in here, but it seems to me like the trial judge just kind of lopped off impulsivity and peer pressure as really reducing Mr. Moore's culpability because she said, maybe this is wrong, but let's think of a case where it's true. This is not an impulsive crime. This is not, and there's also no peer pressure to do it. So that doesn't reduce his culpability quite so much.
I want to set aside peer pressure to talk about in just a moment. But first, I think what the court did here was more than just ignore those two pieces, which it's not permitted to ignore. It gave no weight to factor C10 at all. And factor C10, again, by its text and in light of the legislative history where the court was so heavily influenced by these Supreme Court cases, is categorical in nature, right? It doesn't ask.
Well, sure. I mean, I understand that. I understand that aspect of your argument, but I understood you to be making a broader argument. That part of your broader argument is you can't even take into account sort of the heinousness of the offense itself, and some aspects that a judge might take into account are, well, this offense was especially heinous because they lied in wait. There was no impulsivity. Can they do that?
No, they can't take into account the specific nature, the cold-blooded nature of the case that's explicitly in factor C10 as amended in 2018. And I think that legislative history goes to show that the council intended exactly what I'm saying, that the courts may not look to the nature of the offense, however heinous it may be, to decide that youth does not weigh in favor of.
I mean, I agree. So, I mean, we might be saying two different things. Let's say I agree with you that C10 is always, if we have to sort these factors into buckets, it's always something on the side of the scale of the defendant, the petitioner. But how heavy is that weight? Well, one thing you might ask when deciding how heavily that weighs on side of somebody is, well, was this had the hallmarks of a youthful act? Yes, it is still a side on his scale, but it's not quite as heavy because this wasn't an impulsive crime. It wasn't influenced by peers. It's missing a lot of those elements. So what's wrong with doing that?
I think it's because C10 serves not just as a weight on the scale in every case, but really provides the animating principle of IRA and through which the court should be viewing all of the other factors. And it's clear from the fact that when the United States attorneys started using the heinous nature of the offense in any given case as an argument for why relief should not be granted, the legislature came back and it made extra sure that the court couldn't do that. It specifically said in C10 that youth weighs in favor of sentence reductions against lengthy sentences across the board, despite the cold-blooded nature of or brutality of the underlying offense. It also removed nature of the offense from the list of factors that courts consider. So I think
it removed it from the list of factors that a court must consider, right?
Right. I'm sorry, I misspoke. From the court.
I mean, I don't mean to catch you on a semantic misstep. I mean that as a substantive question, which is, there's these lists, like you have to consider these 10 things.
Right.
And one of those things is not nature of the offense. You can skip right over that court. But then we have a catch-all that says also, anything else that you find to be relevant. So if the nature of the offense matters in a particular case, perhaps as reducing the weight of the C10 factor, well, then you can take it into account. I mean, that is the statute certainly doesn't say on its face, and I understand you have some legislative history that you're leaning on. It doesn't say you can't consider the nature of the offense, which seems like a very easy thing to say if you're legislating, especially where the council was aware that this was being, seemingly overused or thought it was being overused. Was there a proposal at any point during the legislative history saying don't consider the nature of the offense at all?
No, but there was a proposal in, I believe, the most recent round of amendments to put nature of the offense back in precisely for that reason, so that it could be considered, so that it was clear that it could be considered in deciding whether to afford relief, and that proposal was rejected.
Again, but assume that, so that it must be considered. That was what the proposed amendment was. Okay, I think it matters. That one is a mandatory list, that it's off the mandatory list and they're trying to get it back on the mandatory list and they have not been successful. I don't think that follows that it means it's prohibited though.
Well, I don't think the council wanted to eliminate the possibility of looking to nature of the offense. Obviously, the facts of the offense are going to be relevant to assess, for example, the case specific factor of the defendant's role in the offense, right? It's going to be a baseline, which is what the council later said, that it's a baseline from which to assess rehabilitation. But what it can't be as a standalone reason to deny relief. And the reason that we know that, you know, perhaps if the court had, or I'm sorry, if the council had merely removed nature of the offense and left the catch-all, it might be a little less clear. But they also went to the trouble to specify in that sort of lodestar factor C10 that youth mitigates in every case, despite the cold-blooded or brutal nature of the offense. And that language is taken directly from Roper, where the Supreme Court was articulating a concern that if you have a case-by-case assessment of whether youth mitigates, whether youth was a mitigating factor in a given offense, that the cold-blooded or brutal nature of the offense is going to swamp the mitigating impact of youth in the mind of the decider in every case, and that was an unacceptable prospect. And so the council here was responding directly to that concern, which had come to fruition with the arguments that the United States Attorney's Office was making in the early IRA cases, and clarified in C10, you've got to look at, you've got to use youth as a mitigating factor. And what we're not here to do with IRA is to decide that somebody's offense was so serious that it merits further punishment. Because I think—
So if I can interrupt you just for a moment, help me understand, because I'm following along with you. Where does nature of the offense end compared to, I guess, the way I'm thinking about it right now is I understand cold-blooded nature and brutality, and that going to the core of like what the offense is, that this was a murder or a rape or any number of offenses. But what about those other factors that Judge Deal talked about in this initial, not hypothetical, but what the judge did, like, and lopped off this idea of impulsivity and some of the outside factors of the actual, not of the series of events that ultimately resulted in the crime itself that may go towards combating some of those, so some of those youthful impulsivity and other factors that were recognized in the psychology.
So the structure of IRA, which echoes sort of the approach that the Supreme Court took, most particularly in Miller, right, is to recognize that there is across the board a mitigating impact of youth in every case because of these sort of hallmark features. And I should note that the statute doesn't require that all of those hallmark features be present in any individual case. It takes that fact-finding question out of the hands of the judge. And then in addition, over and above that mitigating weight, the Supreme Court has recognized and the council recognizes in IRA that there are individual case-specific factors that can amplify the mitigating impact of youth, right? So this is what Miller was talking about when it described the background of trauma and mental health issues at issue in the Eddings case, and said that background is more relevant in the case of a youthful offender, right? As a mitigation of culpability. And so IRA lays out those individual factors, C2, the nature and history of, the history and characteristics of the defendant, C8, the sort of family background, C9, family background and history of trauma and neglect, and C9, both the role in the offense of the defendant and also the presence and role of adults during the offense, and says, here are some additional factors that may further mitigate culpability and thus further inform the ultimate question of the interests of justice that the court is required to answer.
Can I ask you a question about, you in your brief also refer a lot to standalone, and what do you mean by that? I understand you're talking about nature of the offense might come into play because it's relevant to analyze some of the other factors like were there other people or adults involved, but it also sounds like you might be saying it means sole, or it can't be the sole. And if that's true, it might not be true, but if that's true, I'm just wondering, to what extent do you concede relevance? It might be that the statute is written this way, this might be relevant, but you can't consider it. Or is it, this really isn't relevant in light of what we know? And then how, the second part of that question is, how does that interact or compare to what we've done in the compassionate release statute, where we've sort of recognized the relevance of the nature of the offense to dangerousness, and some of those cases might involve people who were 16 years old when they committed the offense.
I think that the key distinction with the compassionate release statute is that the central insight guiding IRA is that for youth, what's past is not prologue, because of this enormous body of science that the Supreme Court has endorsed that says that the vast majority of youthful offenders, just by virtue of the passage of time and growing up, are going to desist from that criminal activity. And that even experts, psychologists, can't look at the nature of an individual youth's offense and tell from that they're going to be one of those rare individuals, the Supreme Court said, who is going to be a persistent or incorrigible offender. And so it's that insight, I think, that animated the council when it set up this structure, and as Councilmember Allen's letter indicates, originally had nature of the offense in there as a mitigating factor, but removed it when it saw that it was being used as a standalone basis to deny relief. And what I mean by that is that I think IRA's text and that legislative history reflects a legislative judgment that no matter how serious the offense, no matter the nature of the offense, it doesn't serve the interests of justice, which is one of the ultimate questions for IRA, to punish a young person beyond those 15 years because what they did was a very serious offense. So there might be other reasons if they have not rehabilitated, as the science tells us we should expect in the vast majority of cases, that would be a reason that their sentence should not be reduced. But the fact that they did something serious, the need, as the court said here, for the sentence to reflect the seriousness of that offense and to provide a just punishment for such a serious offense, is off the table for IRA's interest of justice.
The government says about a lot of your arguments that you're suggesting that there's just an automatic, there's no argument on the other side. There's no real discretion on as you understand the statute. But what, in your view, is sort of the paradigmatic case where the Superior Court judge would be justified in denying the motion?
So the paradigmatic case is one in which there are continuing disciplinary infractions, issues going on while the person is incarcerated that reveal that they continue to be dangerous and that they have not rehabilitated. That dangerousness inquiry sort of aims towards the question of rehabilitation. And I think it's important to note that I believe it's about 80% of IRA applications have been granted, including in many cases where the offense was very serious. And as the council has watched that happen, they have revisited IRA multiple times, and every time they have expanded its ambit. They have not drawn it back. When the one thing they did draw back was the nature of the offense. And I think it would violate the legislature's clear purpose in doing that, to allow courts to read that back in through Factor 11's catch-all, to use it in exactly the way the legislature clearly intended to stop courts from doing, right? And that is to say, because you committed a very serious offense, I think from a retributive or a deterrent perspective, you need to spend more time in prison. And on that point, the legislature was influenced by Miller and Roper and Graham, all of which emphasized that the case for those concepts of justice, for retributive justice or for lengthy sentences as a deterrent, is just collapses when you're talking about youth who will age out of those characteristics that predispose them to this type of crime. And then just briefly, by the same token as the council removing nature of the offense, we also know that from the beginning, they opted not to include acceptance of responsibility. So that is another factor that it's clear from the legislative history of the statute, while it can be considered as an indication that someone has rehabilitated, cannot be used as a standalone reason to conclude that they are not entitled to relief under IRA. So the court here, I think, abused its discretion, both most clearly in engaging in a judicial fact finding to decide whether IRA's central premise that youth mitigates against lengthy sentences applied in this case, when the legislature made clear through factor C10 that applies in every case. And in using nature of the offense as this kind of standalone punitive reason to deny relief, and also in ignoring the mitigating impacts of those case-specific factors that the IRA factors direct the court to consider, and in requiring an acceptance of responsibility as an essential component for rehabilitation under IRA. So I see that my time has expired, so I will.
Okay, we will definitely give you time for rebuttal.
Thank you.
Hear from Ms. Beskier.
Good morning. May it please the court. My name is Cecily Baskier on behalf of the appellant Derrick Moore. I'd like to reserve 3 minutes for rebuttal. The trial court here made several errors, including but not limited to the ones that amicus has just referred to. Because of the number of those errors and the nature of those errors, I ask that this court reverse the denial of his motion, the IRA motion, and remand for resentencing. Now, one of the most glaring errors is the one related to this factor 10, because the trial court here engaged in impermissible fact finding as part of its analysis of factor 10. And the text of the statute does not allow that. And it doesn't allow it to engage in fact finding in exactly the way that the legislature said not to do, based on the cold-blooded nature of the crime.
Doesn't, I'm sorry to interrupt your point, but if your argument is that the trial court misconstrued the statute and misunderstood what it really requires or prohibits, why wouldn't the remedy be to remand it with a clearer statement of what the statute does require and tell the judge to try again?
I think, Your Honor, if that were the only problem with the trial court's decision here, a remand to do over might be the appropriate remedy. But here there are so many errors, and this factor C10 one itself is so central. As amicus was discussing, it expresses the purpose, the legislative purpose of IRA itself, and the understanding of what interests of justice actually means in the IRA context, which is not the same as in an initial sentencing kind of determination. And so I think taking that error out, and then in addition, another major error is this misunderstanding about the role that treatment for traumatic youth would play and what the challenge program means. We also have, and I could run through the whole list right now, a whole bunch of it.
You could have 100 different errors. You could have gotten every single thing wrong. It still doesn't stop me from being quite reticent about ourselves becoming the fact finders and going through the record and deciding the only possible result here could be release. Is that what you're asking us to say that?
I'm asking the court to say that if you take away all of these errors, what you're left with in the record and the findings that are not erroneous that the court made, there is not enough for it to go back to the court and have her deny the motion again without that being an abuse of discretion. Because Mr. Moore— There's
not enough in terms of the findings that the judge made, or there's not enough in the record period requiring us to comb through it and figure out whether or not that statement's true?
There's not enough in the record to support the trial court, once you undo all of the mistakes she made, to go back and say, it's not in the interest, he hasn't met his burden of showing it's in the interests of justice and that he's not going to be a danger to any person or the community. And that's because when, the way that she's looked at all of these different factors, she's ignored this key underlying principle or pair of principles about the lessened blameworthiness, the diminished culpability of youths, and how that not only affects C10, but it affects the analysis of the individual factors. And when you go back and you look, for example, at his family and community's circumstances at the time of the offense here, it's only mitigating. And she says, well, it also weighs against because he didn't get treatment. And that's just flatly wrong because two reasons. One, he did participate in the preeminent program at the BOP, therapeutic program for dealing with criminogenic thinking and drug substance abuse. And he grappled there, and it's in the record that he grappled there with the circumstances of his youth and this incident when he was around 5. So he goes through all of that, and so she's wrong saying he doesn't do it, and she's wrong to give that burden that he might have to show it because there's the transience of youth. It's another key principle coming out of the Supreme Court and the science that the legislature was relying on here, that in many situations, even with these serious crimes, aging out, maturation, just the passage of, in this case, more than 25 years is generally enough to deal with a lot of those youthful characteristics. And there's nothing in his record here that shows that he needs something extra. This is, he wasn't diagnosed with some disorder that shows he needed to get some additional treatment beyond just growing up, but he got it anyways because he did the challenge program. So there's not enough, and I'll turn in a moment to the disciplinary history. There's not enough there when the trial court takes away, like if this goes back and she has to look properly at the diminished culpability of youth and his particular diminished culpability, which she doesn't give fair credit to, and his rehabilitation, which she doesn't give fair credit to because of the challenge program. There's not enough there to say that even whether it's reasonable probability or preponderance of the evidence, there's not enough there to say he hasn't shown that he's not a danger.
She says something like, she seems to recognize some progress, some positives, and something in the record where she describes him as kind of making progress or on his way, but not quite there. Why isn't it within the judge's kind of discretion to say, I see these adjustment issues. I mean, you might say those are clearly erroneous findings, but these adjustment issues at the one facility, not back in a long time ago, but in recent months, just showing she has a feeling, not a solid feeling that he's ready, that he's shown this kind of rehabilitation. I feel like sometimes they get the issues mixed up with how compassionate release motions are considered, but there are some things in the record that she's relying on, and why isn't it possible for her just to say, especially given that you can come back and ask again, that I just haven't seen what I need to see?
I think it's because the reason she says she hasn't seen what she needs to see is wrong. So a big part of that reason, she says, is, he's got this mixed expression or incomplete expression of remorse, which when you try to read and figure out, well, what's she talking about there? It's two things. It's, well, the mitigation specialist didn't put in a quote saying that he felt remorse about the victims. And yet the judge at the hearing doesn't question or makes no findability that he's not credible in saying that he does feel remorse for the victims who didn't die and for the family. So just looking at, the mitigation specialist didn't quote enough is unreasonable. And then the other thing is, back in 2009, he maintained his innocence when he filed a motion claiming that he was innocent. And to penalize him for more than 10 years before the decision in this IRA case, penalized him for having exercised his legal remedies and maintained his innocence. That's not part of this, and it's not relevant to figuring out if he's rehabilitated. The fact that he expresses his remorse, which again, the credibility of that isn't challenged, shows he got to where he needs to be, and that is relevant to looking at rehabilitation. But the fact that he didn't do it before is not relevant. So she doesn't really have anything there saying, well, he's on his way, but he's not all the way there. And then when you look at the incident in prison, so it says, well, he might've had some adjustment issues because of some inappropriate eye contact with a woman that was then resolved when he was no longer interacting with that woman at Thompson. And also misunderstanding about whether he needs to be on the snow removal crew as well as the kitchen staff. These are not issues that go to bad character or reflect on fitness to be a part of society. And for the court, to the extent the court has the discretion to look at those, it can't look at those without also looking at his behavior after that at the DC jail, which by all accounts is exemplary. And the fact that if he's released, he's going to be in an environment with a support system, which she recognizes is there. So again, she points to a few things, but if you look at the full record, those things do appear to be clearly erroneous or not enough to support the weight that she puts on them. I'd also like to mention something about the way that the trial court writes the decision here, which is, I'm not going to say that like it has to be done this way and the court doesn't have to decide that in this case, but she looks at each individual factor and says, this one weighs against, this one weighs for and against, this one doesn't weigh at all. If she's going to do that, then it does become a harmful error and an abuse of discretion to put something into a factor that's not what the legislature wanted her to put in, because it keeps her from paying attention to what she was supposed to be paying attention to there. And it's also harmful and an abuse of discretion to not look at something in a factor that she was supposed to. So for example, factor 2, history and characteristics of the defendant, is quite broad. She only looks at juvenile criminal history, which as we explain and amicus explain in the briefing, doesn't take into consideration exactly the principles that animate this whole statute, that youth is different and that whatever he did before this offense, he was also experiencing the characteristics of youth. She only looks at that to the exclusion of all of the other mitigating circumstances about his history and characteristic. The fact that she may talk about them later doesn't make that harmless here because of the way she's assigning weight and saying for or against for each individual factor. Perhaps if she did it a different way, maybe some of these mistakes could be seen as harmless, but not the way the trial judge approached it in this situation. I'd also like to turn to the disciplinary history because she points to that as a reason to say he hasn't made a showing of not dangerousness, but she ignores what the US attorney actually said in the letter 2019 comments on the 2020 version of the Second Amendment Act. What US attorney says is a common sense way to look at it, and I believe the appropriate way to look at it, which is the passage of time matters. Things that are older get less weight than the things that are more recent, and the decrease in violence matters as well. And here we have no violence for 13 years between, up until the point, at this point, which is outside of the record, it's been even longer than 13 years. But to look at the disciplinary history without paying attention to this common sense notion that older things will matter less and more recent things matter more, and the absence of violence matters more in those recent things. That is also error on her part. I think the court can look at this as the metaphor of learning to walk, which is that as a child is learning to walk, it's going to crawl a bit, it's going to fall over a bunch of times. There'll be a little bit of gliding and some success and then some falls. That doesn't mean the child's not going to learn to walk. And we see here that Mr. Moore has learned how to walk, metaphorically speaking. And the trial court did not give that the full weight that it deserves. I believe that I've started running into my rebuttal time. So if the court has no further questions at this point, I'll reserve my remaining time for rebuttal.
Thank you.
Thank you.
May it please the court, Brian Hahn for appellee of the United States. The trial court in this case did not abuse its discretion in denying appellant's IRA motion. I think I want to start, we've been sort of doing this in two phases. One is interpretation of the statute, and the second is the trial court's specific application of the statute. So first, in terms of the interpretation of the statute, I think the amicus and appellant sort of overstate many of the things that they've claimed. First of all, when we're talking about the Supreme Court cases, especially Miller, what Miller says is that mandatory life without parole for juveniles is not appropriate. And the court talks a lot about how the trial court judges at sentencing should have the discretion to consider whether or not youth played a role in the offense, and discusses many examples of when that would happen. But the Supreme Court in Miller doesn't say that it always is a factor or that it always should counsel in favor of a mitigating sentence. And to segue that into the RAA, I think the RAA does have some more focus on the defendant. And of course, the counsel did, as amicus says, take out the nature of the offense as a mandatory factor for the court to consider. But as Judge Deal pointed out during his questions to amicus, the counsel didn't say you can't consider the nature of the offense. And the counsel could have said that.
But I mean, we just talk about the language of C10 though.
Sure.
Because I mean, I guess it's a little bit artificial to me, the way that Judge Smith sort of just like put each factor into different buckets, you know, but I mean, that nobody's really quibbling with that so much. If a judge wants to go down that road, that's fine. But one point that your opponents make is if you're going to sort them into buckets and you look at C10, C10 needs to at least fall on the side of the scale of the defendant, the petitioner, because it says you're supposed to take in the diminished culpability of juveniles, notwithstanding, you know, any heinousness of the offense. That looks to me to be a straightforward reading of C10. So why don't you tell me why? Is that wrong? Am I misreading it?
I don't think so, Your Honor. I think that C10 in most cases does tip in favor of the defendant. And the question there is how much?
Well, so I mean, but let's just focus in on the phrase you used in most cases. I suppose my question is, why isn't it a straightforward reading of C10 that if you're going to isolate that as a category and you're going to put it in one or the other bucket, always needs to factor on the side of the defendant, and it might be outweighed, in part by sort of certain characteristics of the offense, but it's some weight on the side of the defendant, and that's certainly not. Judge Smith said the opposite, right? At page 30, well, let me see. I've got it as page 306, but that's a document you don't have.
Sure.
At page 72 of the appendix, or 23, or her opinion, she just says, this factor, given the circumstances, does not weigh in favor of granting defendant's IRA motion at this time. Strikes me as wrong. Am I misreading the statute, or am I misreading her opinion, or maybe a little bit of both? What do you think?
So I think that I think my interpretation of what her opinion says, and if you look a bit ahead on that page, she says that the defendant's juvenile age certainly plays a part in the court's determination of his culpability. And I think that perhaps what Judge Smith is doing when she split them into buckets, she's talking about C10, but that she's jumping a little bit ahead because she's weighing the nature of the offense, which she is allowed to do under C11, against C10 here, I think a little bit. And so, I think that if she had put sort of the second part of that paragraph later in the opinion, either when talking about C11 or later when she's talking about on page 24 to 25, the evidence taken on each of the factors taken together.
So you don't take issue with my interpretation of C10 that it is in fact, or with the appellant's interpretation of C10 that this is some weight on the side of the scale of the defendant, and you think this is sort of just an infelicity of the trial court where she could have mitigated all of its force, sort of if she had just put this somewhere else, and we shouldn't read that as being an important factor of her opinion?
Yes, Your Honor, I agree with that. I think that I don't think she errs because maybe she's jumping ahead, but I do think that even if she is only thinking about C10 independently as a factor when she's talking about that, I think that error is harmless, as the government argued in its brief, because it's clearly what she is doing there is that she is weighing this factor against other factors that she is permissibly allowed to consider.
And then I guess my follow-up question then, it's kind of more, it's harder to answer in sort of a precise way because this sort of heinousness of the offense really is quite pervasive in Judge Smith's opinion. You know, it's heavily stressed in the facts. It's heavily stressed throughout the analysis. It seems to be doing the lion's share of the work in a way. I mean, you might disagree with that description. I'm interested if you do. It looks to me to be doing the lion's share of the work against early release here, which strikes me at least as being in some considerable tension with what C10 is instructing trial courts to do, which is, you know, these cases are going to come up generally. You know, these are cases where somebody has served at least 15 years in prison for something that they committed when they were youth, which means they probably had no, you know, serious criminal record, which means the cases are almost always going to be quite serious and heinous. And what the counsel said was, well, not put it inside. I don't think it says put it aside entirely or you're prohibited from considering it, but it does say, let me just get the exact language, you know, the diminished culpability of juveniles, despite the brutality or cold-blooded nature of any particular crime. It seems like, at least you should say, it is given some less than substantial weight when doing the calculus of release. So really the focus, the serious focus should be on rehabilitation and not, you know, punishing somebody or making sure that they spend enough time for something they did before if it was heinous enough.
Yeah, so I'm not sure that's true, Your Honor. I think that C10 as a factor encompassed in of itself does, I think, have more focus on the, you know, the hallmarks of juveniles as it says. But there are other factors in the statute that are required to be considered by the court that do, it seems, it's hard to disentangle them from the serious nature of the offense. So, for example, the trial court's required under, I don't remember which subsection this is, but is required to take into account the statement of any victim. And when a victim is saying, you know, making an impact statement and saying, this is how this crime affected me now and into the future, that's about the seriousness and the nature of the offense. And I think it's primarily about that because, you know, the victim doesn't have an impact statement without the offense having done something to them. And of course, in this case, there were 3 victim impact statements.
So why doesn't that cut the other way, that the council specifically allowed an area for the seriousness of the nature of the offense? Why, if that necessarily comes from there, why shouldn't we read that as, well, that's where they allowed it and it shouldn't be in other places?
Well, I think that it's not that they only allowed it from there. I think that is one of the other factors that includes that almost necessarily as a consideration. And I think that as a result, you know, the council didn't say you can only consider the nature of the offense when it comes to the victim impact statement. It said it took it out of a mandatory factor, which was not even in that factor. I think it was in C2, which is a different factor. And then, but then left in the catch-all, which said the court is allowed to consider any other information that the court deems relevant to its decision. And of course, the decision being, 1, whether or not the defendant remains dangerous or is not dangerous, and 2, whether or not it's in the interests of justice for the sentence to be reduced. And I think in terms of both of those analyses, I think as Judge Beckwith said, you know, this court's recognized that the nature of the offense is important, at least to some degree, to at least a dangerousness finding.
But don't you think if a trial judge put all of the, you know, weight of the decision in that victim statement and said, you know, I'm denying this because this had a horrible effect on the victims' lives, and by the way, it was the most heinous crime ever, and then that was it, don't you think that would be kind of antithetical to C10 and sort of the general legislative history and purpose of this? You know, it seemed, wouldn't it be a runaround of what the council is trying to get at in removing that language, you know, and in the discussions about how a lot of these cases are being decided on this basis, and we don't want that.
I don't think so, Your Honor. I think that the council said, you know, we want to de-emphasize perhaps the nature of the offense here. But the council did not say it plays no part. And the council didn't even say that it couldn't outweigh any of the other factors. I think you can imagine a situation where it wouldn't be in the interest of justice to reduce someone's sentence, even if they were juvenile when they committed it, and even if there's only good news about how they've been rehabilitated. Because I mean, I don't want to, sort of wax poetic about the most evil, like Hitler-like figure as a juvenile who ever existed, who killed and tortured many people before, being sentenced.
I'm not sure
to
though,
life,
because
but-
a lot of times the heinousness is so related to the youth, it's like, that's why it's so heinous, because this is a kid and he's not thinking, his brain isn't, so I'm not sure the the more heinous it is, all of a sudden gets you into, I mean, I guess if it makes you dangerous, or you're saying the interest of justice would be notwithstanding everything we know about the science of youth and
I think both of those things, Your
Okay.
Honor. I think that, if the trial court determines, if the nature of the offense is so terrible that the court can't be confident that this person's not dangerous, that would be an abuse of discretion, so long as the court appropriately weighed that against all of the other evidence. And I also think that the court could say that in the interest of justice. And of course, this would be a very rare case. I mean, I can't tell you about a case that I know about where like this might be a thing that the trial court might do. But I don't think that the statute disqualifies the trial court from doing that. It didn't strip the trial court, the council didn't strip the trial court of its discretion when deciding these issues when amending the statute. It only sort of tried to change the balance of how the factors were to be considered. And I think that.
Do you think the nature of the offense in this case is, where does it fall on the spectrum of importance in what the judge is ruling, in a correct ruling from your perspective?
I don't know if my personal opinion on how bad the offenses are really matters. I think that in the exercise of discretion, two judges can come to different opinions, and they are still properly exercising their discretion as long as they're not making any legal errors, and their factual findings aren't clearly erroneous. I do think that the trial court found that. And my personal, I think I personally agree, although I don't think that matters at all, that this crime was particularly, heinous and troubling. Appellant appears to be one of the two ringleaders of this group of people. They lie in wait in an apartment for a drug dealer or a person they think is dealing drugs to come into the other apartment. When that person doesn't show up for a while, they just ambush people coming in, two women, their children. They shoot and kill a 16-year-old even after her mother begs them not to, and they shoot the two women in the head, and both of them manage to survive. Not sure how. At least it doesn't seem in the record how they managed to survive that. And so, but for them not surviving, that's a triple homicide. It is one homicide. I think, both the planning nature that the court highlights and his sort of leadership role and his role as the triggerman are all important factors when trying to decide what the nature of the offense is and how much it matters to the balance of factors in this case.
But its relevance in your view is to dangerousness?
I think it's both to dangerousness and the interest of justice, Your Honor. And I think that, it's one of the things that the court, it's the whole reason we're here, I think, Your Honor. The whole reason we're here is because appellant committed these crimes, and now he's in prison for it. And he's asking for a second look at that statute. And as this court said in Williams, it's his burden to show both that he is, again, not dangerous, and that it's in the interest of justice to reduce his sentence. And the trial court permissibly found within the exercise of its discretion that he had not done either of those things. And if there are no further questions, I'd ask the court to affirm the trial court's order.
Can we get into some of Ms. Beskier's argument about the application of some of the factors?
Sure.
I felt like we were at the very high level
Oh, sure.
statutory
Yeah, sure.
interpretation.
We can definitely. Sorry,
And there's,
I appreciate the chance to not.
yeah, I mean, there's a number of things that you said which strike me as, being true, including, the trial court's disregard of the challenge program, where it seemed to give that no weight. Seems fairly troubling to me. Do you not think it is?
I disagree that the trial court gave the challenge no weight. I think the trial court gave the challenge program weight. It said that he completed it. And it's not clear to me from the record what about the challenge program addressed the error that appellant says. Appellant says, that was a little bit tangled. Appellant says that the trial court erred by saying that he did not address things like his childhood trauma, like this fire incident that he accidentally said with his brother, other things related to his youth. And he relies primarily on the challenge program to say, this is why he addressed that. And I at least couldn't find anything in the record that described what he did in the challenge program, other than that it was an intensive drug treatment program. This is on page 13 of the mitigation specialist report. And so, it may very well be that he did address it in the challenge program. It's just that it's not on the record. And it's appellant's burden to put that forward. I don't know what he did in the challenge program. I don't know if he even talked about his traumatic youth. I don't know. And if the court finds in the record something that says that, so be it. But I was unable, at least scouring the record, to find out what exactly he did, other than that it was an intensive drug treatment program. And the court says, he finished this program. He did get that drug treatment. That was good, and gives him, it weighs that in his favor. Doesn't weigh it in his favor, in the specific box that appellant wants the court to. But I don't think that's an abuse of discretion either. I think there were a couple other places appellant talked about. There's brief talk about remorse. I think that when we're talking about what the factor is whether or not C5, the defendant demonstrated maturity, rehabilitation, and a fitness to reenter society. I think that remorse is something that the trial court can consider sort of at the high level. And I don't think the trial court erred here in saying, he submitted an affidavit for his IPA motion saying that he was innocent, he wasn't involved. And then the mitigation specialist report sort of omits the other victims other than the victim who died. And then now, finally, at the IRA hearing, he is now expressing remorse for all these things. And so, that doesn't weigh in favor or against. It's sort of as the court described, as Judge Beckwith pointed out, it's sort of he is maturing and contemplating, and and maybe he'll get there. Maybe in 3 years when he gets to file another IRA motion, or 3 years after that when he gets to file a third, maybe that would be enough for the trial court. But, sort of this one-off instance here now when he's, looking for release, I don't think the trial court, I think, permissibly said, I don't weigh that in or against him at this point. I don't know if there are any other specific
What about the
errors.
disciplinary record
Oh, sure.
piece that was being considered? It looked like we have a 13 years plus of nonviolent history, and then essentially what's weighed against him is a dispute about which duty he's supposed to be on, and he was looking at me.
Yeah, so I think in talking about the disciplinary history, I did want to point out, I think the government's brief at page 45 says there were 4 stabbing incidents. There were only 3 stabbing incidents when I've re-reviewed it, I think. And I think that was just my error. But I do want to say, there's a stabbing incident in 1995. There's one in 2002, and then there's another one in 2007. And then there were 2 other non-stabbing, but still assault incidents within that time period. And I think the trial court, again, didn't abuse its discretion in looking at that and saying, there was a period of time in which he had serious problems, and that he committed these pretty terrible assaults, one of which he was convicted for and still has to serve a sentence for. And then for 13 years, he hasn't had any violent offenses or violent disciplinary things levied against him. But he has had a couple of things where he's gotten in trouble with the jail and been disciplined. And so that also is, he is getting better. It is definitely better than the period before that. But I don't think the trial court is required to ignore the fact that appellant did have many assaultive incidents that he was disciplined for.
No, but is it fair for the trial court to put weight on, like I said before, when I perhaps unfairly characterized it as a complaint of, oh, he's looking at me, and a dispute about the particular detail? I mean, you have to go back really far in time to get to the assaultive conduct, and that's fine. That exists. It's fair to consider. But the only two complaints that exist since then for an almost 15-year period seem to me, for lack of a better word, just kind of petty.
Well, so there were two actual disciplinary things. The first one is in 2011. I think that's when he floods his cell by hanging a line from a sprinkler in 2011. And that's disciplined as the destruction of property. And then there's the refusing.
There was no suggestion that he did that intentionally. He hung a line from a sprinkler and ended up flooding his cell. Okay.
Correct. I'm just
the phrasing threw me a little bit. Okay.
Sorry, I'm just trying to clarify what the record says about disciplinary history versus undisciplined conduct, et cetera.
Sure.
And then the second one is the refusing to obey the order, which is the work assignment issue that we've been talking about. And the separate thing here that he wasn't disciplined for was the sort of adjustment issue where he was, I don't know how in-depth the description is, but the description is that he's staring at this particular, I think, female prison guard, and that he is, making eye contact. Like, I would describe it as sort of like being creepy. And I don't, that's a gloss that I'm putting on it, but that's what the description says to me. And that they have to reassign him from a work duty, and they have to move him from one cell to another in order to stop that behavior from happening.
I mean, that's a pretty good 13-year record, though, in BOP. We've reviewed enough of these compassionate release motions, and I often don't know what to do with BOP disciplinary records because I have no idea how many of these infractions are based on like the irrational whims of guards who decide, she doesn't like him. Maybe she thinks a lot of prisoners stare at her. Maybe a lot of people get sent away from that. I have no clue. But in a 13-year span, that's a very good disciplinary history, I'd say. You don't think so?
I mean, I think that the trial court could look at that and say that seems like a pretty good disciplinary history. I think the trial court could also look at it and the prior disciplinary history and say, again, as Judge Beckwith pointed out, it looks like you're doing better. It looks like the defendant appellant here is contemplating and maturing, but it's not quite enough yet for a sentence for release. And I don't think that's an abuse of discretion. And I think that, I also have no idea, I think, about how often this particular prison guard complains about inmates and gets them reassigned. But that's not the government or the trial court's responsibility. That's appellant's, because he has the burden to show that this wasn't as big of a deal as the BOP made it out to be, or at least the bare description of it in the records is. And I'd also say that that's probably also why it's an abuse of discretion standard for this court, is because the trial court's there on the ground, able to, evaluate these things. The trial court held a hearing, heard, it's not clear if it was testimony from witnesses. They said they were statements. Some of them were cross-examined, some of them weren't, but heard from witnesses and heard from the defendant. And I think that it was not an abuse of the trial court's discretion to look at this record and all of this in the way that Judge Beckwith described, that appellant, had taken steps and credited the appellant for the programs he had done. The court also credits him for, having job offers if he's going to be released, for his good, release plan when if he were to be released. But to say, I'm still not convinced at this point that you are not dangerous and that the interests of justice would favor a sentence reduction. And now, unless there are any other questions about those specifics, I'd ask the court to affirm the Superior Court's order. Thank you.
Thank you. Ms. Terrell, we will give you a few minutes for rebuttal.
Thank you, Your Honor. Briefly, I just want to clarify that IRA's grant of discretion to weigh multiple factors in individual cases is not a license, as Johnson tells us, to ignore the factors that are meant to guide the court's discretion in keeping with the statute's remedial purpose, and certainly not a license to ignore C10, which represents the council's legislative fact-finding that youth weighs in favor of reduced sentences in all IRA cases, such that a court cannot do what it did here and look to the facts of a particular offense to decide otherwise, contrary to what the legislature has concluded. Likewise, a court cannot consider, Johnson tells us, inappropriate factors. That includes the nature of the offense when it is read back in as a standalone reason, apart from dangerousness or rehabilitation, to deny relief in a manner that's clearly contrary to the legislature's purpose as reflected in those 2018 amendments where they removed nature of the offense.
So I have a question about like the position. So let's just take at a very broad level. Let's say I take your position to be, you know, if a trial court decides that somebody is non-dangerous and rehabilitated, they're under IRA, they're basically bound to grant release. What is C6 doing in the statute then, taking into account, like, how does that have anything to do with rehabilitation, which these are the statements of the victims? And it also, you know, if we go back up earlier in the statute, it says not just dangerousness, but interest of justice. How does that have anything to do with rehabilitation?
Yes, so I think briefly, the interests of justice that Ira is talking about are informed by those factors they've laid out and by C10's instruction about the mitigating impact of youth. It is unjust, the legislature has concluded, to imprison youth who are less culpable, more amenable to reform beyond those 15 years if they have rehabilitated.
So that's then why, I mean, shouldn't you just strike out interest of justice then? I mean, you could just, that shouldn't even be in the statute because you could just go with the finding of non-dangerousness. You're saying those two things are duplicative of one another.
I think particularly because, you know, to distinguish IRA from your typical sentencing statute where issues like retributive justice are in play and deterrence, I think the reason IRA talks about the interest of justice and focuses the court through those enumerated factors, particularly factor C10, on mitigating impacts of both youth and individual circumstances, is to draw the court's attention away from the serious nature of the offense and toward the reasons why, despite however heinous the act the person committed in their youth 15 or more years ago was, why it is in the interest of justice to reduce their sentence if they have, as the science predicts, rehabilitated.
Then what about the victim statements, or is that supposed to be a one-way ratchet the other way?
No, and victim statements are not, I think, as government's counsel has suggested, a proxy for the serious nature of the offense. I think in IRA, just as in the normal sort of statute for victims statements during sentencing, that reflects a recognition that it serves the interest of justice for victims to have an opportunity to be heard, to confront the defendant and tell them about the pain that they have caused, to inform, in the case of IRA, the court of any potential current dangerousness. So if, for example, a victim is still receiving threats or something, the C6 would provide an opportunity for that.
It's about the offense for which the defendant is in prison. It's not talking about like later threats that come up. I mean, C6 says it's a victim statement. Okay, sorry.
Oh, excuse me. I'm saying that the opportunity for the victim to be heard provides an opportunity for any additional information that the victim might have that would go to current dangerousness to come up beyond what happened with the offense. But I think it also reflects a recognition by the counsel, and that has played out in fact, that in some cases, victims will support a reduction in sentence. And I would note in addition that it has been entirely common for courts in those 80% of IRA cases that have been granted to do so in cases where victims take no position and where they oppose release. And that is because IRA is not a mechanism to settle private scores between victims and offenders
I mean,
by,
let me just give you a
imposing
hypothetical.
punishment.
Like, let's take Sandy Hook. Let's take somebody who went through and killed, make it, I don't know what the number of dead children was in Sandy Hook, but let's say it's something like 10 to 15 children. And you go through the factors and say, okay, diminished culpability, check. That's a weight on the side of the defendant for sure. Victim impact, this destroyed a community. It also has wreaked fear throughout the United States. And in no way could I conclude that in the interest of justice, despite believing that this person is rehabilitated, he had mental health issues, he's now on all the appropriate drugs, and he's not going to reoffend. But I look at C6, I look at the interest of justice, I say this person no way should ever see the light of day again. I take it your response is that is a misapplication. IRA would say you have to let them out under those facts after 15 years.
Not that you have to let them out. Oh, yes, under those facts where where the person has demonstrated rehabilitation and non-dangerousness. Yes, IRA reflects, particularly through C10, a legislative conclusion that it does not serve the interests of justice, no matter how heinous the underlying offense.
I still don't see why C6 doesn't say otherwise. I guess I just haven't understood I haven't understood your answer of what C6 is doing in the statute and what the interest of justice factor is doing earlier in the statute. Why those remain in the statute if it's just about dangerousness and rehabilitation, which you could lop off interest of justice and C6 seems totally incompatible with to me.
Again, I think interest of justice is there to draw the court's attention to the injustice of lengthy punishments, as the Supreme Court has recognized. Lengthy punishments, here it was 66 2/3 years, which is effectively a life sentence, for crimes that are committed at an age when it is sort of documented that young people have diminished culpability and that they are under the influence of factors, characteristics that they are extremely likely to grow out of just through the passage of time. So culpability, that Miller says, I think, is central to the notion of retributive justice. And because it's diminished here, that rationale for extending a young person's sentence just collapses in the case of youthful offenders. And IRA reflects the legislature's judgment that we need to remedy those kind of lengthy sentences for young people where they have, as expected, rehabilitated. And what C6 is doing there is not providing a mechanism for additional punishment or retribution for the harms done to victims, but rather coming at it from more of a restorative justice perspective, which I think is supported by the fact that at the same time that the council enacted IRA, it also created a pilot program for victim offender mediation in juvenile cases with the notion that it would benefit all parties, right? It reflects a recognition that there are more paths to justice and that justice contains more than simply retribution for past offenses, particularly in case of juveniles where retribution really doesn't hold the same weight given their dramatically diminished culpability. I just want to briefly mention on the case-specific factors, our position is that those factors only go in one direction. So while, for example, you may not receive the benefit of mitigating weight based on the role in the offense here, that doesn't mean that factor, which was intended, we know from its sort of antecedents in Miller, was intended to capture mitigating circumstances that amplify those youthful characteristics, can be weighed against relief. And just, Your Honor had asked about peer pressure earlier, and I had set that aside, and I just want to note that the underlying science recognizes, and that's contained, for example, in the Steinberg article that the legislature quoted in its 2016 report at footnote 2, contained referenced in Miller in the American Psychological Association's brief, shows that the mere presence of peers can dramatically increase risk-taking behavior, and that influence can be powerful even when it is indirect. So as opposed to direct peer pressure, just the mere presence of peers where where the defendant would be trying to seek their approval can be mitigating. And that, we think, is why C9 calls for the court not only to examine the extent of an adult's involvement in the offense, but also more fundamentally, whether an adult was involved at all. So with that, unless the court has any additional questions,
Thank you.
I will stop down. Thank you.
Ms. Baskier, we will also give you some time for rebuttal.
Thank you, Your Honor. There are a few points that I'd like to address coming out of the discussion, the points that the government was making and amicus. First, the trial court is allowed to look at the seriousness of the offense in some ways, but it can't do it, as Judge Beckwith said, in a way that is antithetical to what the statute says and the purpose says in other ways. So, for example, it's okay to look at the seriousness of the offense to understand what the victim is talking about if the victim in its statement or his or her statement speaks about the offense. And it's okay to look at the seriousness of the offense to understand the role that the defendant was playing. Sort of what happened, how bad was it, what was the defendant doing? So C9, but it's not okay to do exactly what the legislature said not to do in C10 and come back and do that. First of all, to do it in C10 with impermissible fact finding, and then to come back and do it and say, well, under this catch-all factor 11, we can look at anything. It's the council made a determination that the seriousness or heinousness of this offense is not relevant to, let me take that. It's whether it was cold-blooded or planned or not is not what the court is supposed to look at because of this concern that the Supreme Court expressed in Roper, which is there is such a strong and impermissible likelihood that the terrible nature of the crime is going to make it impossible for the court to give the kind of attention that it's supposed to give to the reduced blameworthiness, the diminished culpability of juveniles and their capacity for reform. So what the trial court did here is not one of the okay ways to look at it. And another part of its error is—
Let me just float a question. Let's say I'm a trial court, I'm looking at C6. And I've got two different cases, one in which a victim, the crime was, dealing drugs on their stoop. And that victim says, that's really ruined my life. I've never been able to rest since. It's 20 years later, but I still can't get over it. And I'm very affected by it, and it's ruined my family. The other one is a crime like this, where somebody's, daughter was killed and two women were shot in the head. And they give the exact same victim impact statement. They say, it ruined our life. This has torn apart our family. Can you factor in the seriousness of the offense when evaluating how much weight to give those victim statements? Like this one is, I'm not going to give any weight to person number one, because that's an insane thing to have ruin your life. And I take they're being too dramatic and hyperbolic. This other one is quite reasonable. That is a serious, the type of thing that could break apart a family. It could make a community feel unsafe. And so I'm going to take into account the seriousness of offense under C6 and crediting the victim impact statement and finding the interests of justice don't weigh in favor of releasing this person, given the impact on the community that he's had. Is that a permissible way to think of the seriousness of the offense?
I don't think so, Your Honor, because in both cases, what the trial court is doing is looking at it from a retribution standpoint of what is the appropriate way to punish for the impact on these victims. And what we know from the science and the Supreme Court and what the legislature said here when it passed and then amended IRA.
Why does it need to be retributive though? Why not like the victim's abilities like to continue to feel safe? Why that doesn't strike me as a retributive type of value.
So I think it's a different point if you're talking about the ability to feel safe. And I think if there's anything in the record that substantiates a victim's statement saying, I don't feel safe, such as amicus mentioned, evidence of threats or—
You don't think that it would be substantiated for somebody to say, I don't feel safe for you to let the murderer of my daughter and the guy who shot me in the head 15 years later out of prison, even if I have no evidence of what, I don't, maybe he had an exemplary disciplinary record in the intervening 15 years, but that does not make me feel safe given what happened. And maybe he uttered, I'll come back for you. If I ever get out, I'm gonna come finish the job. Let's throw that in as one of the factors of the offense. You don't think that could be taken into account?
So I don't think that you can take into account, I don't feel safe as part of the dangerousness inquiry unless there's something else there. Now,
Right.
if there's a
I'm
statement.
not trying to factor it into the dangerousness inquiry. I'm saying under C6 and the interest of justice, that one thing that that a trial court can take into account is they should be able to feel safe after everything that happened to them. And even if, this defendant did everything he could in the last 15 years to rehabilitate himself, and I see no evidence that he's actually dangerous. What I'm hearing from the victims is that they won't feel safe, and for very good reason, because they endured something so horrific. And so that, I think, in the interest of justice means not as a retributive point, but like weighing these two individuals, like this group of individuals that won't feel safe if he's let out, and it might wreak havoc on them mentally and for some good reason, versus his right to get out. I think that in the interest of justice, he should stay in a bit longer.
I think I disagree with Your Honor in saying that the victim saying, I don't feel safe going to the interest of justice is different from a retribution, because I think that them saying, I don't feel safe, if you're not looking at it as part of dangerousness and you're only looking in the interests of justice, it's saying, I don't feel safe because he needs to stay in jail longer for what he did to us and to the community. And that's about retribution. That's about the appropriate punishment. And we know from the science and the Supreme Court that juveniles, no matter how terrible the crime is, are not as, the retribution doesn't play out because they're just not as blameworthy. And I'd also like to mention that the trial court here says, oh, this case, the facts of this is on the more serious end of the spectrum. And I think if the court looks at the cases that are in appellant's appendix and other decisions from the Supreme Court, we see that this is actually, unfortunately, not one of the most heinous, most severe situations. Yes, it's terrible, but unfortunately, it's kind of run of the mill for what these IRA cases involve. And there are other applicants who have been released for committing planned, therefore not impulsive crimes in public places, not under the influence of drugs, unlike here. And so just factually speaking, the trial court is also wrong when it looks at it in that way. And to the extent that the court can look at C6, at the victim statements, which I disagree, but if I am incorrect and the court disagrees with me, I think that C6 by itself, or C6 plus the opposition of the United States Attorney's Office, C4, those are not enough to be dispositive on the interests of justice when we have the purpose of this statute, as Amicus said, is about remedying the injustice of these lengthy sentences for juveniles who are not as guilty despite the horrible things they did and who can reform. And in this case, the evidence shows that Mr. Moore did reform. I disagree with the arguments made by the government, and that's also set forth more in our brief, but particularly in the reply, Mr. Moore's reply brief identifies several places in the record where the court does talk about the challenge program, where Mr. Moore and Mr. Moore's counsel talk about the challenge program. And it would be unreasonable for this court to say that Mr. Moore did not meet his burden of showing that the challenge.
Am I right that was a 500-hour program?
500-hour program, and what we know from publicly available materials that the BOP puts out, it has to take place over at least 9 months of time. It's separate residential housing. And Mr. Moore said enough in his papers and the argument of counsel here, and the government didn't dispute that he completed the program, that he was asked to stay on as a mentor, that it's a therapeutic program. None of that is in dispute. If it were, certainly the government would have brought that evidence out to us. So I see that I am out of time, so I will rely on my briefs and the briefs of Amicus for further arguments. And I ask this court, again, reverse and remand for resentencing on the IRA motion, and as well on the COVID motion, remand for further proceedings. Thank you.
Thank you very much. Thanks to all of you for your briefing and your arguments today, and the case will be submitted. The last case on this morning's calendar is Kenneth Adams Jr. versus United States, number 19 CF 1210. Sure.
I think it's still morning. Good morning, Your Honor. May it please the court. My name is Michael Lawler and I, along with co-counsel Adam Demetrio, represent Kenneth Adams on his appeal to this court. Your Honor, we have submitted multiple issues in our opening brief, but I hope to, given the amount of time, argue just two of those, which would be the issue of severance and the Brady claim. And I would ask the court to reserve 5 minutes for rebuttal. Your Honor, at the pretrial motions hearing, the government submitted.
Can I just, before you jump in,
Please.
I just want to make sure when you say you want to address severance, the briefs on both sides seem to conflate misjoinder and severance quite a bit. So are you about to talk about severance exclusively, or are you going to address misjoinder as well?
I'm sorry, Your Honor, and you're right. I have been using those two terms.
Something can be properly joined and yet require a severance.
We are arguing misjoinder under Rule 8, and candidly, we believe we should prevail on the issue. But otherwise, severance under Rule 14, even if the cases were
Understood.
Joined correctly because of the overwhelming prejudice that would ensue if these, as they did, 3 separate events went to trial. Regarding misjoinder, Your Honor, at the motions hearing in the beginning of this case, the government posited that these three events were tied together because the original robbery was then followed by a confrontation between the brother of the victim and Mr. Adams, which then led to an attempted shooting in Awick against Mr. Spriggs by Mr. Adams. And then the following day, the government posited there was another shooting of Mr. Spriggs, a shooting at Mr. Spriggs that resulted in the death of the victim. And so they posited that this confrontation between Mr. Spriggs and Mr. Adams tied these events together. That evidence never came to bear at trial.
And when it didn't come to bear, did you renew a motion for a severance?
A renewed motion for severance was not made, Your Honor.
Okay. I don't know why I care what evidence came out at trial when the trial court has to rule on joinder and severance pre-trial and there's not a renewal of a motion. So, I mean, I'm happy to talk about what the representations and what the indictment and what was in what the trial court knew about joinder before trial happened. But if you didn't renew a motion for a severance, I'm not particularly interested in whether or not it all came to fruition. And I don't know, why do you think I should be?
Well, I think you should be, Your Honor, because the government made representations here that Mr. Adams' counsel relied on, and then the court relied on. And in the absence of discovery, which trial counsel repeatedly asked for, there was no reason to believe that evidence wouldn't come to bear at some point.
That's a good reason to renew a motion for a severance after the evidence comes out. It's not a reason. I don't really understand what you want me to do with it. You want me, like, we should therefore sanction the government?
No, Your Honor. Forgive me.
No, I just, so here's how I think of it. The trial court makes a ruling that these are properly joined and doesn't sever pre-trial. And we've got to live with sort of the record as to how the trial court ruled on those objections. If there could have been a later motion to a renewed motion to sever, then I'm happy to take, if there had been, I'd happy to take everything that happened at trial into account. But without that, I just don't know how I could say the trial court erred in joining the cases and denying a severance at a point in time where the trial evidence hadn't been spun out yet. I mean, we've said time and time again that this is, you evaluate the propriety of joinder based on what I think usually the indictment or the evidence that you have going into trial.
Well, I mean, it's hard to determine, Your Honor, whether or not, I mean, these are obviously different events that occur on different days. So I think most trial counsel, the potential of misjoinder would sort of jump off the page of the indictment. There's three different dates.
Sure. Let's talk about that though. My questions are not as hostile
No,
as they
I-
might seem.
I take no
I don't want to
hostility.
talk. It's like, I think when you talk about misjoinder, you should really focus your argument on why you think, these offenses were misjoined without getting into like the evidence that didn't quite come about, because it might not matter so much. It might be that even the evidence as represented pre-trial wasn't enough to warrant a joinder or required a severance. And I think we might want to talk about that a little bit more.
And I agree with that, Your Honor. I certainly will respond to the court's inquiry, but I do believe it is relevant to the inquiry, and not that it should be just sanctioning the government. And I don't think the onus should be put on trial counsel that if the government represents that these events, three separate events on three different days involving three different victims, which, as I said, trial counsel, competent trial counsel, the notion that a Rule 8 motion should be filed is going to jump off of the page. And then the trial court relies on a proffer by the government that, well, this is why they're properly joined. And then at trial, yet again argues an entirely different basis why joinder is appropriate, as they are arguing on appeal that no, wasn't because of the confrontation between Mr. Spriggs and Mr. Adams. That's not why these cases were properly joined. They were properly joined because there was a beef in the neighborhood. Problem is that never materialized. There was no evidence of that. And the court—
Well, there's some evidence of that, right?
There is evidence that minimal evidence. Mr. Spriggs acknowledged that there are two.
What about the text from Miss Tinch saying, those uptown, blah, 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 they robbed me. Suggesting some beef between the guy she's talking to and what the uptown, I can't remember the name. There's down bottom, uptown, something.
I guess we could just say up and down for sake of ease. And she did say this was the up crowd that had robbed her, but there was never, Your Honor, there are references to the fact that, there is an up and there is a down, but there was never any evidence that the fact that there is an up and a down in some way led to these events. In fact, there was no evidence.
Okay, so let's just take it at a more basic level then. How about the statement to Miss Tinch, your brother's next? That came out at trial. That's some connective tissue between the February 15th robbery and the shooting at Mr. Spriggs, at least I know the jury acquitted of the 18th, and on the 19th, they convicted of something different than AWIC against Mr. Spriggs.
He was acquitted altogether of the events on the 18th.
Right. And convicted only of the murder on the 19th. Maybe I assume some weapons offenses as well. I don't remember. Yes. But why isn't that enough connective tissue to hold these cases together? Well, frankly, let me start with an easier question. Harder for you, I think easier in my mind. Why aren't 18 and 19 perfectly joinable under, the similar, these are similar acts?
Well, I mean,
these are shooting at the same guy.
Let's start out, again, Your Honor, maybe the court and I have a different view about sort of the nature of the evidence and the quantum of evidence. But bear in mind too here, that as to the robbery, the victim in court said, Mr. Adams did not rob me. Mr. Spriggs, regarding the February 18th event.
Yeah, but the jury concluded otherwise. The jury, the government is free to join cases with, good faith basis. You don't look at joinder after the fact based on what the jury convicted of.
Yes and no.
Yes, only yes.
Well, Roper says, Your Honor, that it's a hard sell to say that two cases were properly joined, or that it was properly admitted other crimes, which is where these cases, often overlap, is whether there's evidence of one is going to come in as 404B evidence or Drew evidence in the other trial. And the Roper case says, that's a terribly hard sell when the defendant is acquitted of that second event, which is what happened here.
Well, it did that under a harm analysis, not under an error analysis. It said if they're acquitted of one, that can't be harmful. That's what Roper said.
That's fair. But Your Honor, in terms of whether or not, that comment, your brother's next is enough connective tissue, to borrow the court's phrase. Number one, that was not a statement made by Mr. Adams. And I mean, the best extrapolation of that could be, we're going to rob your brother next, not that we're going to shoot at him and try to murder him on the streets. So, but Your Honor, I do want to get back to, just you said, the cold hard facts about whether or not these cases are properly joined. I mean, I don't know how to separate out that the reason the government said they were properly joined never materialized, but what you are left with is an indictment that charges a robbery on day one, an AWIC involving an entirely different victim on day two or several days later here, and then a murder on day three.
So I think their answer, and we can talk about it, is I think they're really left. I don't think they're going to have much luck arguing common scheme or plan. I think under 8A, they're left, or that these crimes are of similar character, because they're really not. So they're really left with 8A's connected together language. And 8A's connected together language, we've generally interpreted it to mean that there is a substantial overlap of the evidence. So I think that's their primary argument. And they say, well, you're going to be able to get evidence of the robbery in on a separate trial of the AWIC and murder, as establishing, it's some precursor to the latter. Evidence that, we're going to go get him shows the ID of who eventually went and shot at him. That's their argument. So what's wrong with that?
That's where I started, Your Honor, that argument is invalid because, again, Your Honor used connective tissue, or we can talk about Drew, or one event led to the other. The cases obviously talk in a variety of terms, but none of the evidence of one of these crimes, it would have been admissible at a trial of the other. There's nothing about the robbery of Miss Tincher that lends itself to the shooting of Mr. Spriggs, other than the fact that this is her brother. Likewise, there's no evidence that the shooting of the deceased victim is in any way connected to the events the day prior. Particularly, Your Honor, and again, when you look at the evidence that the government adduced, the statements they made, and then the evidence adduced at trial, Miss Tincher said that Mr. Adams was not involved. And then there is this cryptic comment, your brother's next. I agree, but that's the sum and substance of the evidence and, again, the connective tissue. The shooting in the alley against Mr. Spriggs says that Mr. Adams didn't do it, and now you have some cryptic, again, out of court statements that were made, either that, and I think the best you can draw from that is that Mr. Adams was present. Neither of those trials gets charged or indicted, but for the fact that the government wanted to paint Mr. Adams as a gun-toting thug on a week-long crime spree. And that is why ultimately, Your Honor, on both under Rule 8 and under Rule 14, that these cases were misjoined, and absent misjoinder, given the paucity of evidence as to the first two events and the lack of any sort of theory, or more importantly, evidence that tie these events together, that they were not properly misjoined. I'm not sure if I have 1 minute and 20 left on my 15 minutes or on my 10 minutes, but
I think we'll probably, I'll let Judge Beckwith is presiding and she'll decide, but I think we'll probably give you a little extra time, because I have one or two more questions on
Please.
misjoinder. I'd just like to talk about harm for a second. usually the harm that flows from misjoinder or failure to severance is this sort of, it's kind of what you just articulated. And so the government has gotten the benefit of some propensity evidence, they painted him as a bad guy. And so the jurors are going to possibly convict. Even if they're not so sure beyond a reasonable doubt they committed any one offense. This is a bad guy who's running with gangs, who's playing with guns. You got to convict him. The jury's verdict doesn't look anything like that, though, because the jury actually acquitted him of the AWICs against Mr. Spriggs on the 18th and the 19th. And they acquitted him of the armed aspect of the robbery on the 15th, which, I think some of the evidence on the 15th would have come in as relevant to the murder on the 19th, but not vice versa. So when I think about harm, I think, well, maybe they shouldn't have been able to join the 15th robbery with the shootings that happened later. The shootings themselves, I think, were perfectly properly joined, to be frank with you. And if that was the misjoinder, well, where's the harm? Is it possible that they convicted Mr. Adams of a murder based on a belief that he engaged in a simple robbery 4 days earlier, of which they did not convict him of the armed aspect and they did not convict him of the AWICs? That seems very unlikely to me. Is it possible they convicted him of the robbery, albeit not while armed, because of the murder that happened later? I suppose that has a little bit more legs for me, but even that's a little tough to see given that they acquitted of the armed aspect. So could you just, am I getting something wrong? Am I thinking about harm the wrong way? And how do you think this verdict evinces that the misjoinder harmed your client?
Well, Your Honor, I'm not aware of a case where once you talk about propensity and misjoinder and harm, looking into the verdicts as they are in this case, that can be a fool's errand because the danger, of course, is that a robbery is no thing, is not nothing, I should say, forgive me. You just heard a case, a murder, 2 shootings. We're talking about a murder here. So in our jobs in the criminal justice system, perhaps a robbery seems like an insignificant event, but number one, it's not. But
I don't mean it's an insignificant event. It sounds like an unlikely thing to prompt somebody to use a propensity inference to convict somebody of murder, meanwhile acquitting them of the armed aspect of the robbery and the 2 AWICs that are related to the robbery via family. They're, possibly related to the robbery via family.
Well, Your Honor,
you have to kind of tell yourself a bizarre story of what the jury thought to kind of use the February 15th. If they shouldn't have heard about the February 15th offense, it would be a strange story to tell yourself that, and they wouldn't have convicted him of the murder if they hadn't known about it.
well, again, Your Honor, I think to try to speculate about, what went into a jury's verdict is challenging, but I'll say this, 2 things. Number one, as I said, as to the first 2 events, both victims in the courtroom with Mr. Adams said he did not commit those offenses. And then in terms of harm, Your Honor, I don't believe that you can look at harm just like materiality and the Brady issue in some sort of vacuum. When you look at this trial as a whole, it was, I want to use a word that's not polite in court, but this was just a nonstop litany of witnesses who came in and denied making statements, said that the police had put them up to this. Some were impeached. Only 2 were impeached with prior statements who made an identification. Others were impeached about supposed statements that were made by others. And on top of that, Your Honor, you have this Brady issue where one of the 2 witnesses who identified Mr. Adams as being involved in the last event, this was suppressed so that the jury couldn't hear about the fact that this same person had lied during a previous investigation. So I don't think that the answer is just to try to speculate about what the jury's verdict was, but to look at sort of harm and materiality in terms of all of the evidence. So with that, Your Honor, I hope the court will permit me a few minutes of one rebuttal. Thank you.
We will indeed. Thank you.
Good morning, and may it please the court, Dan Lenners for the United States. I hope my brief didn't conflate misjoinder and severance, but in case it did, I'll just briefly touch on the Rule 14 severance issue. As Judge Steele indicated, the trial evidence is irrelevant to joinder. It is only relevant to whether the court should have severed this, and in this case, whether the court plainly erred by failing to sever the charges based on the evidence at trial because defense counsel never objected. The defense has never identified any plain error that the court made by failing to sua sponte sever during trial. And to the degree that the evidence at trial differed from the government's pretrial representations, and I do not agree with defense counsel's characterization of the trial evidence, that is not relevant to the joinder argument. Joinder focuses solely on the indictment and pretrial representations made by the parties. As the DC Circuit made clear in Bostick, the government need merely allege, not prove, the facts necessary to sustain joinder. Trial evidence cannot render joinder impermissible and is thus irrelevant to our inquiry.
Can I actually start you out on joinder? I know you said you were going to jump to severance, but am I right that under 8A, which it seems to me that you have what, 4 or 5 options under 8A in terms of why these would be properly joined? Are they of the same or similar character? And I want to just focus on the 15th versus the robbery of Miss Finch. Am I getting the name of Tinch? Tinch. And the shooting, let's just say on the 19th to make it easier. You could lump 18 and 19 together if you want. So I just want to take you point by point. Do you think they're of the same or similar character?
No, Your Honor.
Based on the same actual transaction?
No, Your
Honor. Part of a common scheme or plan?
Yes, Your Honor.
Okay, and then connected together?
Yes, Your Honor.
Okay. Let's talk about connected together, which I think is the stronger of your arguments. And when thinking about whether or not 2 offenses are connected together, I understand the inquiry to be something like, is there a substantial overlap of evidence between them? Is that right? Or do you want to supplement that or amend it?
In Vines, this court said 2 crimes are sufficiently connected together if proof of one crime constitutes a substantial portion of proof of the other.
Right. I take it you're not contending that the February 19th shootings constituted a substantial portion of proof of the February 15th robbery of Miss Tinch.
I think the trial court could have thought about it that way, but that's not our argument. Our argument is that evidence of the robbery and the threat that these men from 21st Street, aka Up Top, made to Miss Tinch, in which they specifically threatened her brother and named his crew, it was Langston Terrace or Down Bottom, was this rival gang. And there was ample evidence in the record of a beef and a long-standing beef between these 2 groups. Bryant Mayo testified that the beef had been going on his entire life.
Was Miss Tinch part of the beef? Was she part of the Down Bottom crew?
Not that any evidence indicated.
So why is the robbery against her any evidence of the beef?
Well, the robbery against her is not evidence of the beef. Her communications after the robbery are, as the court indicated, she texted one of her brothers or sent him a Facebook message that said these Up Top guys robbed me, and identified them, the 3 men, one of whom was the defendant. So she identified them by the neighborhood with which they were associated.
Here's how I think about it. And there's, I think I'm thinking of Ray was a case where it was an 8B case, but because they said the defendants were properly joined, they talked about it sort of like an 8A case. where there was one robbery where I believe the defendants stole some jackets that they were then wearing at robbery B. So that's some connective, and the robbery B was just 15 hours later. And the court said, you know, you don't need any evidence of the earlier robbery. Like you can sanitize that evidence and say, well, yeah, they had those same jackets 15 hours earlier. You can bring in that evidence in crime B, but the evidence of the robbery is really irrelevant to crime B. And I feel like that here about the robbery of Miss Tinch, you could have a statement. So, I mean, Mr. Adams didn't say, your brother's next. Somebody else in the crew said, your brother's next. The text saying, you know, the down bottom boys, if I'm getting the name right, that down bottom robbed me. Well, that doesn't need to identify Mr. Adams either. The fact that she listed him in the name of people who robbed her seems to me to be totally inconsequential to establishing the beef. And so I guess, like, why isn't it, what about the robbery of Miss Tinch is relevant to Mr. Adams shooting, again, I would say at Mr. Spriggs on the 19th, although it's not clear the jury credited that either. What about her being robbed is relevant?
If I might just start off with not answering your question and then answer it,
Sure.
Which is, I think that you're thinking about this the wrong way. These sanitizing the evidence would go to whether the court exercised its discretion properly in not severing them under Rule 14. It's not relevant to the joinder analysis. And this court interprets Rule 8 broadly in favor of initial joinder.
I mean, I want to pause you there because the question is, are the offenses connected together? And you're citing, to me, what you're citing to is tangential evidence that is not the offense of robbery against Miss Tinch. These are statements that are made about down bottom. Has nothing to do with the robbery at all. So, you know, if I don't think I'm thinking about it the wrong way. I'm saying the offense of Miss Tinch being robbed, not a member of the up top crew, doesn't establish anything about there being a beef between these two crews. It's just the statements that you want. So let's, you know, if we could change the hypothetical a little bit, and let's just take this to, you know, a really heinous, brutal assault and attack on somebody, at the end of which they uttered the phrase, and now we're going to go rob the hardware store. And then, you know, the day later, the hardware store is robbed and they want to say the same people did it. I understand that the statement, do you think that those two cases would be properly joined because they're connected together?
I think that's a harder case. And the reason it's harder case is here you're talking about violent crimes by a neighborhood crew aimed at a woman and her brother. So they're more closely connected than a brutal assault and a robbery of a hardware store, because this is both connected together and part of a common scheme or plan involving this crew targeting this other crew, and not just the other crew, but
what is the common scheme or plan? Like, was a conspiracy charged among anybody? Was there, how did one further the other?
The common scheme is this targeting with violent acts by one crew against another crew, and not just another crew generally.
She's not part of the crew.
That she is the sister of someone who's a member of the crew. They threaten that he's next. She immediately warns him and says, they're after you.
The threatening that she's next sounds a lot to me like that we're going to rob the hardware store tomorrow. Like, okay, get that evidence in. What does the robbery have to do with it, though?
Again, Your Honor, it's it's not just the threat, but it's also the fact that they're willing to engage in armed violence. This was an armed robbery. I know the jury acquitted the defendant of knowing, I guess, that the gun was going to be used, but he was an active participant in a violent robbery, armed robbery of a woman who was the sister of someone associated with the crew, and threatened that he's next. She immediately reaches out to both of her brothers. She's told to get a gun. I mean, this isn't in our brief, but there was evidence that the brother responded, you need to get a dog, and meaning you need to get a gun to protect yourself. And all of this would have come in to show the context, motive, and identity of the people who subsequently violently attacked Mr. Spriggs, you know, on three different occasions. And again, I think the fundamental precept of Rule 8 is this court interprets it broadly in favor of initial joinder. the trial court properly found that evidence of the robbery would have come in. The defense never suggested the possibility of sanitizing the robbery away from the crime only to this threat that was part of the connective tissue. And so I have trouble seeing how the trial court erred by not considering that possibility when I'm not
Again,
aware of-
my point is not that the trial court should have sanitized it as a when she thought about joinder, it's that the robbery aspect of it seems pretty tangential to what connects these things together, which to me is mostly the threat. The communications after about saying, you know, she got robbed. Again, if that's all that came out, then you don't even need, you know, implicating Adams, or you don't need to charge the two crimes together. It's some bit of evidence that would come in a separate trial for the February 18th and February 19th shootings.
and I guess I disagree, Your Honor, because saying your brother with that Langston stuff, he's next for what? It's meaningless unless you know the context of he's next is the context.
He wasn't
of
robbed
armed-
next. I mean, that was part of your opponent's point, which is, you know, that's a funny statement to mean they're going to go shoot at him.
But it wasn't he's next, meaning he's the next person we're going to give a lollipop to. He's next, and we have just committed an armed robbery against you. And so I think that part you can't sanitize away. It would render that part of the statement meaningless. And in any event, if the court disagrees and thinks that the robbery should not have been tried with the AWICS and the murder, as I agree with Your Honor that it's hard to see how there was any harm here. There was overwhelming evidence that the defendant was the murderer. There were 4 different eyewitness identifications of him as the murderer. The idea that the jury somehow found that because he committed a robbery 4 days earlier, that impacted its verdict of the murder is pretty much preposterous, given the split verdict, which was not only to acquit him of the armed part of the robbery, but also to acquit him of AWICS and of obstruction of justice. So certainly the jury did not accumulate this evidence and find that this defendant was simply a bad person and render its verdict on that basis.
Can you explain the jury's verdict for me? You know this evidence better than I do. Can you just reconcile what the jury might have been thinking with its February 19th verdicts? Why no AWIC against Mr. Spriggs, and yet the murder is your understanding just, well, they had IDs, they credited those and thought that he killed this man, but they didn't credit the motive as being targeting Mr. Spriggs?
That's if one wants to try to reconcile these verdicts, that's the best I can come up with. There was a concurrent intent instruction. The evidence, the shot spotter evidence indicated that the defendant fired 5 times at a group of 5 people who were all standing within 5 to 10 feet of each other, one of whom was Mr. Spriggs. And so it was a first-degree murder verdict, meaning the jury knew that the defendant, or found that he came with the intent to kill. And apparently they decided that the evidence was insufficient to find that his intent was to kill Mr. Spriggs versus someone in that group, but it didn't matter because of the concurrent intent to and the zone of danger that all 5 people were placed in. The court didn't seem to have many questions for defense counsel about the Brady issue. I will merely point out that it would have been extraordinarily weak impeachment, even had it been allowed, of Miss Watts with regard to the late untimely disclosed or disclosed after trial statement she gave to the police in a 2012 assault with intent to kill investigation, where she was interviewed by the police, did not initially give truthful statements to them. The next day gave more information. And the day after that went into the grand jury, told the truth that she had in fact seen the shooter and who did it and how many times he fired, and said that she had previously not been truthful because she was scared. That is the opposite of corruption bias. That is the opposite of a witness who is willing to undermine the reliability of the proceedings. She is in fact being truthful when placed under oath in the grand jury. And she was also impeached with many different aspects of her testimony, including the fact that she would not say on the stand that the defendant was the shooter, even though she had previously told the police she was 100% certain it was.
And
so
Mr. Adams has asked us, I believe, if I remember the motion correctly, well, the first asked us just to hold the argument in abeyance, and we denied that. But I believe as part of his request was to hold the appeal in abeyance while their current 23-110 motion plays out. And I take it that you oppose that, that you oppose that.
I don't see any reason to. It's not in the record before this court, but Mr. Adams' counsel did send me their 23-110 motion. I think I'm correctly characterizing it as a single issue ineffective assistance of counsel motion based on trial counsel's failure to renew a severance motion based on the evidence at trial. And I don't think that this court could easily write an opinion in which it rejects his arguments on appeal about severance based on the plain error standard without impacting the trial court's decision on that motion. And certainly, given the time it sometimes takes this court to write its decisions, the trial court may well decide that motion.
Easy, counsel.
If there are no further questions, we'd ask that the judgment of the trial court be affirmed.
Thank you, Mr. Lenners. Mr. Lawler, we will give you a couple minutes.
Thank you, Judge. So Your Honor, we were sort of sparring about this robbery, which I thought the court was giving too little weight to the significance of it in terms of propensity evidence. And the government just stood up here and talked about the very violent nature of that robbery. And then the court and the government started to contemplate how it is the jury's verdict, which on its face seems inconsistent. Well, the previous question with the court is, how do you explain this seeming inconsistency if there was misjoinder or a failure to sever? And those 2 points are specifically what we're arguing here, that this robbery was misjoined, it's violent propensity evidence. And these two different events should not have been tied together. And Your Honor, finally, in terms of the notion that this was overwhelming evidence, as I said earlier, there was not a single witness who testified about the February 19th event who gave consistent pre-trial and in-trial testimony about an identification. Not a single one, which again leads into the notion of the significance of the failure of the government to fail to disclose that Ms. Watts had previously lied in an investigation surrounding a shooting. And then I said last point, but that was wrong. One final last point, and I mean it this time. Your Honor, there were two witnesses who talked about, up top, down bottom. They were Mr. Spriggs, who sort of poo-pooed the existence of it and flat out denied that it had anything to do with this case. And then there was Mr. Mayo, who was led through the fact that this sort of geographic beef exists. But the significance isn't the fact that these up and down people may be beefing. The significance is whether or not there was any evidence that any of the acts in this case were tied to that supposed beef. This is, as I said, below the government originally said there was a confrontation between Mr. Spriggs and Mr. Adams. There wasn't. Then they changed course and said, no. These cases should go together because there's a neighborhood beef. Well, the abstract of a neighborhood beef shouldn't impact the ruling below or the ruling here that these cases were joined together when there was no evidence that that caused any of the conduct here. Thank you.
Thank you, Mr. Lawler and Mr. Lenners. We will take this case under advisement, and for now, the court is adjourned.
Oh.